The next case to come before the court is ALW, and ALW. We're just like 1 minute early. I assume everybody's ready to go. We're not waiting for anybody or anything?
Ready when you are.
All right, you each will have 15 minutes, and you can reserve up to 5. Just let me know what you want.
Thank you, Your Honors. May it please the court. My name is Jason Wallace, and I represent Appellant Anthony Wilson, and I would like to reserve 5 minutes for rebuttal. Anthony Wilson asked this court to reverse the trial court's decision to remand this case back to the trial court to reopen the case, appoint a casa guardian ad litem, add him to the case plan, and allow his voice to be heard. Your Honors, this case is about a father not being able to have a voice in serious matters regarding his children. In fact, it appears that his counsel in the trial court simply chose not to listen to him at all, thus effectively denying his right to counsel, be present, be heard, and then later to represent himself. Your Honor, after reviewing the briefs, I believe that they are sufficient to render a decision in this matter, but I'd like to give this court a brief overview of the facts, because all of the issues raised around those facts, they revolve around the same facts, and they all involve Mr. Wilson not being able to be heard. I think talking about those facts and hearing them, they are all quite concerning. This case started out in a dependency, abuse, and neglect matter filed in the Summit County Juvenile Court in November of 2012. Father began filing motions in December of 2012. The magistrate then adjudicated the children dependent January 13th of 2013 without father being represented, without father being there. That was later overturned. The dependency was dismissed, and then they had another adjudication in February of that year, of 2013. Dad, at that time, made it known that he didn't have any information, that he was stipulating kind of hesitantly because he wasn't receiving any information, he didn't know about this. And one other factor I think I left out is that father was incarcerated at this time. He is no longer incarcerated, but at this time he was. So he is relying on his attorney to provide this information, and he never received any information until the day of the hearing. At the time, the caseworker indicated to the court in February of 2013 that father wasn't even put on the case plan because they weren't sure. They didn't have any contact with him. They didn't know if he'd be able to assist in this matter. Well, I believe father could assist in this matter, and the court simply chose not to hear him. Dad wanted to tell everybody about what was going on, about his efforts, about what he was doing, his parenting progress, his certificates that he's earned, all of his achievements and his positive behavior. At no time did anyone want to hear it. And in February 2013, he asked for the information about schooling records, medical records. He had concerns about his children. The court granted that request. When this case closed about a year later, he still never received any of those records.
Counsel, let me stop you because the facts are rather complicated here, but my reading of the briefs led me to believe that throughout this proceeding, father had requested to be transported from prison, and the court permitted that, and he was physically present for a hearing at least, correct?
He was present for one early hearing, okay, and then there was an issue with the counsel that did withdraw in May of 2013. Right. He was never present at any other hearings, and his counsel was never there either, well, even though the journal entry dismissing counsel wasn't effective until much later.
Right. Well, was there not also another hearing where he asked to be to participate via video, and the court granted that?
Yes, Your Honor.
Okay.
And there were some technical difficulties, I believe, with that one particular hearing.
Right. And that's not the court's issue. That was just things happen.
Yes, Your Honor. Okay.
All right. Go ahead.
And so then, just to jump ahead, I think that really the crux is where we were going. And I think that's the biggest thing. So he receives an attorney right around February. He doesn't have any of this information, even though he's filing motions and responses, and he's filing quite a few things earlier than that. The attorney comes aboard. The attorney seeks to withdraw around May, June of 2013. He gets that condition to him at a hearing. The court tells him that they will allow him to withdraw. However, they do not journalize that for more than 6 months later. And so at that time, there were 3 other hearings that go by that father's not present for, that father's not represented for. Father's filing numerous motions in that time period, that 6 months where there is no attorney, and it was orally indicated to the attorney that he could withdraw. The court then declined to hear those motions.
I can't remember, so refresh my recollection. I know you just said he wasn't there for the hearings, but did he get notice of them?
I believe he did get notice, Your Honor, yes. And he was filing numerous motions and objections and asking for extensions of time so that he could participate in these proceedings. And it was 6/18/2013 that the withdrawal by counsel, it was finally granted and journalized. It was orally granted at that hearing prior to that. It wasn't journalized until December 6th of 2013, on or about almost the exact same time the case closes. The case closes about 11 days later. So this denied father the chance to be heard this entire time. All of the errors revolve around that. All he wanted was to be heard. The justification for this denial of counsel is simply that, well, father probably didn't have anything to offer. But that's not true. Father offered to the caseworker allegations of current abuse that were happening during that time period. And he was saying, look, I have concern for my children. I have concern for what's going on here. And they were not hearing them. He wasn't able to go to the court and have these discussions and tell the court what was going on. And just the fact that...
And how he's been incarcerated, how would he be able to tell the court what was going on?
In the beginning of this matter, he finally received some phone contact with his children. He was able to write some letters finally. There was an issue with contempt and then now he's falling through. But I don't want to get sidetracked on that. He finally was getting some sporadic contacts with them and they were reporting to him. So they were telling him these things and he was just trying to pass them on. So it was firsthand from the children that he wanted to go because there were a lot of serious things going on. And during this time period...
And hearsay from him to say what the children had told him.
Yes, Your Honor, I agree, but still, as to take the report and to figure out the validity of it, I believe there's something there at least to investigate when it comes from father talking about what's going on with his children. At all times, he never maintained that he wanted to disrupt the children with their placement or do these things. He just wanted to have his voice be heard. He was concerned about medications. He was concerned about over-medicating. And in no time was he actually able to have this discussion. There are just numerous instances where father was not able to participate.
Well, let me ask you too, because the CSB says when you say the trial court erred in not appointing you counsel, of course, their response is, I never requested you counsel, and you didn't follow local rules.
Well, I would argue that he never received counsel in the first place. He's not having any contact with him. This attorney's not telling him what's going on. He's not talking to anybody. The attorney that was appointed to him eventually, that attorney was appointed originally to another party in this case. And then he gets switched over to him. So I don't know that he was...
What's the relevance of that?
Well, the idea is that if he has other information, if he has any predispositions based upon information he's discovered, then there could be a bias or there could be an issue there that would affect his new client. If he,
well, that's entirely speculative unless there's something in the record.
And I agree, it is speculative. But the overall point is that this attorney didn't contact him, he didn't talk to him, he didn't do anything. And so then somewhere there is an error. It could be that the attorney erred by not coming to appearances prior to the journalizing of the entry indicating he could withdraw, or that the court erred by not having an attorney there, or the court erred by not allowing Mr. Wilson to be heard in hearing his motions he's filing in the meantime. So somewhere...
Well, what I was asking though, and maybe I didn't ask it correctly, after his counsel withdrew, he didn't, I guess you agree, he did not request a new counsel.
He did not, Your Honor. I agree.
Okay.
Wholeheartedly.
So they're saying, well then, you should have asked for counsel.
And the alternative, then his motions should have at least been heard in a timely fashion. Then his objections to his filing should have been heard, because he either has counsel or he doesn't. And this is a case about having your cake and eating it too. You can't have it both ways. It has to be one way or the other. You either have an attorney or you don't have an attorney. So that means that the attorney's representing you or you can file pro se motions. And so here, it was both ways for at least 6 months. And that just doesn't seem fair. It denies him his right to parent, to be a part of these proceedings. And it's just the fairness is gone. His voice was taken from him. And the answers in the brief from the agency do appear to contradict each other. It is either he didn't have an attorney or he did have an attorney. It cannot be both ways, Your Honor.
And you're getting into your rebuttal time if you want to say something.
Thank you.
May it please the Court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee, we are asking this Court affirm this case. The argument that Appellant's counsel brought up today is an interesting story, but it's not supported by the record. This is a case involving a father who was serving a 6-year prison sentence. The children were removed from mother, were returned to mother with just protective supervision. This was not a man whose voice was not able to be heard. He filed numerous letters to the court. He filed numerous motions. The court did hear and respond to some of those motions. There is absolutely nothing in the record to show that there was no communication between counsel and client.
Well,
what's in the record?
Let me just stop you if you don't care.
Mm-hmm.
In regard to the court allowing his counsel to withdraw, that was court-appointed counsel.
Court-appointed counsel.
Okay. Had he requested pursuant to the local rule to get that counsel appointed?
Yes.
Why did he have to request again to get new counsel if he already requested counsel to begin with?
He requested for counsel to be removed also.
Well, I understand.
So once counsel was
but
removed.
that happens all the time. I mean, you know, in criminal cases and so forth, that you just don't get along with your counsel. And so you say, Judge, I don't think this guy's representing me. We've had a break in our relationship. Counsel here comes in and says, you know, I can't represent him.
Right.
So how does that get the court off the hook of making sure he has counsel after that guy's gone?
Well, these cases are different than criminal court. The rules provide that you have to ask for counsel.
And
You're not entitled to any counsel that you want. So he simply didn't agree with what his attorney was saying. It's not that they were not talking.
Why did his attorney ask to withdraw?
His attorney asked to withdraw based on a difference of opinion that impairs his ability to communicate effectively or represent him further. So that shows they were talking.
Okay.
But he had asked to have counsel removed before that. He filed numerous letters.
But the court didn't grant that.
The
court
court
granted the attorney's motion to withdraw.
Right, because he was represented by counsel and he's just filing letters, which are not the proper vehicle to get it before the court. And the court orally said at that July 24th hearing that the court would grant that motion, but counsel wasn't present and neither was the defendant. So I'm not sure how the defendant's going to argue that he believed that this statement by the court that the court would grant that motion was something he relied on. It was not journalized until much later.
Well, okay, let me just back up just a minute, because, and obviously I'll go through the record, but maybe you can help me here a little bit. He requested counsel, he got counsel. Counsel and he, for whatever reason, whether it's his fault or counsel's fault, it doesn't really matter. The point is, his counsel was allowed to withdraw.
Right.
Why does he have to go back and request counsel again if he already requested counsel as an indigent person to begin with? He has to request counsel each individual time, you're saying?
Correct.
Why?
I believe that's what the rules required. Otherwise, if you allowed somebody to say, well, we were having a communication break, but it's really they just don't like each other, then they're going to go through how many different court-appointed attorneys. So if you asked to have, he could have proceeded on his own. There are many people at juvenile court, parents who proceed without counsel. So he didn't say, if you ask for appointed counsel and you want the attorney removed and the attorney's removed, why should the court assume that you then want somebody else?
Well, except that here the court didn't grant his motion. He granted the attorney's motion to withdraw. So isn't it, if the attorney, I mean, I feel like there's ethical obligations on the attorney's part as well as the court's part. If you grant the attorney's motion to withdraw, you can't just say, okay, you're on your own out there now.
There's nothing to show that counsel didn't tell the client that.
No, I'm not talking about that. I'm talking about if you are representing somebody, an indigent defendant, and you want to withdraw because you can't get along with them or whatever, right? You're basically saying in your brief, I think, that the court does not have an obligation to make sure there's another attorney appointed.
Correct.
Why? I'm just not understanding that.
In this case, when you have a client who's saying they want their attorney to withdraw and the attorney wants to withdraw, that is made known to the client. And if the client wants another attorney, they can. He asked for counsel for the disposition adjudication. He had an attorney for that. He stipulated to the adjudication. He stipulated to the disposition. So frankly, all of those other things afterwards don't have any relevancy on the dependency anyway. The important hearings as far as adjudication and then where the child is going to go, Dad was there with an attorney on February 21st. There was a hearing. He was there. He stipulated to everything. So down the road, if he says he wants a new attorney for a review hearing, you just go in, you talk about how the case is going, what's going on. Dad was still in prison. And the court was hearing his voice. He was indicating he was having trouble communicating.
But statutorily, if not constitutionally, statutorily, he has the right to have counsel represent him.
This is a juvenile case. So I don't believe that he has a right once he asks for an attorney and then the attorney is removed to just say, well, now I just get another one sua sponte. He should have to ask for another one. He didn't. And that's what the rules say.
And how did he know the attorney? Because you had said earlier that he didn't know that the attorney had withdrawn.
He knew that the motion was filed, but the hearing that he wasn't at because of the equipment was that July 24th hearing where the court said in the transcript that the court was going to grant the motion to withdraw. So then he files all these other motions and he's trying to argue, well, I believed I was pro se because I didn't have an attorney because the court said they were going to allow counsel to withdraw. He wasn't at that hearing. Counsel wasn't at that hearing. So I don't know why he's going to ask this court to rely on an oral statement by a court that he didn't even hear.
But on the other hand, how would he know to require or request new counsel be appointed, and we're holding that against him if he doesn't know that his counsel had withdrawn?
The order didn't come out until, I have to look at the timeline, November 13th. So everything that went on in between, he would have to believe he had an attorney. The order did not come out until November 13th.
Well,
he's trying to act like
he believed that he had an attorney. No one was showing up at any of the hearings. Who was acting on his behalf?
He was at the adjudication and disposition in person. He was at the May 16th hearing by video. The only hearing that he missed was that July 24th hearing because of the equipment, and his attorney did file a motion to have him brought back. The court denied it. The only hearing where nobody showed up was that one review hearing. And I don't know why the attorney wasn't there. It's not in the record. But that was the only attorney where no one was there, and the only thing that happened at that hearing was a review where they talked about what was going on in the case. They set another date for hearings on Dad's motions, and the court orally indicated that it would grant the motion to withdraw since Dad wants the attorney withdrawn. The attorney's having a difficult time representing him. So this whole idea about this is a man who's in prison and his voice can't be heard is just untrue. And if he was concerned about ongoing physical abuse or something like that, he could have filed a complaint with CSB. That would be the proper way to go about it, not to get medical records that he...
Isn't that why you have an attorney, so you know what your rights are?
True, he had an attorney at that point, though.
And the other thing is, you say that his voice was being heard. There's such things called meaningful participation, meaningfully heard, not just having a voice. That's why the statute, and I'm not trying to give you a hard time.
No, I know.
That's why the statute says you're entitled to an attorney.
Correct, but he was not asking for what he was asking for was school records and medical records after adjudication and after the disposition. They had nothing to do with the ongoing review of the child being with mother with protective supervision. He had meaningful representation. He has no argument that he didn't. He just didn't get everything he wanted. And that's why you have an attorney, for an attorney to tell you that's not relevant, that's not something you're entitled to. And the court told him, the medical records are protected by HIPAA. The school records you have to get from the school, the agency doesn't have them. So he was asking for things that CSB didn't have or that we were prohibited from giving to him. That doesn't mean he did not have meaningful representation. He had meaningful representation throughout. His arguments are that he wasn't heard on certain things. When you look through the record, the court did, in fact, listen to everything he had to say. He's arguing about school records. He's arguing about medical records. The court advised him why the court couldn't give them to him. So it shows that his voice was heard and he did have meaningful representation. If he had a different attorney appointed on November 13th, at the end of the case, I believe counsel indicated it was 11 days before the case closed, what difference would that have made? He had an attorney throughout. There's absolutely nothing in the record to show that that representation was not meaningful. This counsel did everything he could to get Dad brought back for hearings, to have Dad be able to be allowed to participate by video, and he gave his client good advice on things that although the client may want it, they're not relevant and they're not necessary for this part of the proceeding. What was done at that point was reviewing how mom was doing after she completed her case plan, which was the goal, reunification with mom. The child was removed from mom. So I don't see anywhere where he can argue that he didn't have meaningful representation of counsel. He had counsel all the way through. Just because counsel didn't do everything that he wanted doesn't mean that counsel did not effectively represent him.
Well, he said that while he was there, he wrote, a number of letters and never heard anything back from his attorney.
And I don't know whether that's true or not.
Well, do we have,
Okay. I mean, well,
is there anything else from the lawyer to say that it's not, or is it?
the only thing that the lawyer said was that they were not having effective communication. So perhaps he was writing the same letter that the attorney had already written back. I don't know. But that's in the record, and that's, for the court to decide whether that was credible. But regardless, at the time of the adjudication and the disposition, he was represented by counsel. There was no issue at that point between counsel and the client. He stipulated to the disposition, stipulated to the adjudication, had counsel throughout, and counsel did make every effort to have Dad be able to be present. Also, with regard to the case plan, Dad stipulated to the disposition, which was when the case plan was adopted, so he stipulated to that too. And he was having visitation with his children by phone call, so that would be the only thing that would be added to a case plan for a father in prison, likely. There's nothing in the record to show that there was something else that would have been on the case plan, and the goal would never have been for reunification with Dad. He was in prison and the child was removed from the mom.
So what was the last thing that was entered by the court? You said they had the withdrawal of counsel in November, and then what was the final order?
Protective supervision of the agency was terminated, and the child is back in the legal custody of mom.
Okay, so my point with that is, it seems to me what you're saying is that after the dependency adjudication, you said he stipulated to all that, right?
Right.
Okay, and after all that, then really, you don't have any reason to have counsel, period.
You really don't, especially when you're in prison and you don't have an objective on your case plan. What he wanted was just medical records and school records. For whatever reason, he thought they'd have some merit.
And I understand this particular case, but I don't know that we can make law just for one particular case.
Right, I understand that.
So my point, I guess, is your argument is there's no prejudice not to have counsel after the adjudication.
There's no prejudice if you've had an attorney appointed, the attorney asked to withdraw, you've asked for the attorney to withdraw, you know the attorney withdrew, then I think that the rules require that you file another motion for another court-appointed counsel. And I do understand that the court's concerned because, if you say, well, in this case it was fine, and down the road other folks who may actually be denied effective representation. But I do believe that is the best course of action. If you have an attorney, and that's what they do in criminal court, they say, I'm not getting along with the attorney, they have a conversation about it, then they ask, do you want another attorney to be appointed, and then they appoint someone, because you have the right also to represent yourself.
Well, sure, but that's not done here. Nobody said to him, do you want another attorney, do you want to appear pro se, he didn't even know what was going on, really, you're saying, because that wasn't adequately communicated to him.
Well, he got the journal entries, so it was communicated to him by the court. The journal entries
later on.
Well, right, or later on. But when he got the journal entry saying that counsel was withdrawn, it was all the way at the end of the case. So he wouldn't have been able to file a motion for another attorney anyway. So in this case, I don't believe that. I think it's a moot point in this particular case.
Thank you.
Thank you.
Thank you, Your Honor. The issue about no prejudice. The father didn't have any visitations. They were not ongoing. His contacts were limited. He filed contempt motions that were not heard. He had lots of issues about his phone contacts. He didn't agree with what was happening. And in the end, his residual rights weren't protected, as they would have been if he had an attorney, if he was able to be heard. There would be different outcomes with potential visitation, with contacts, with other things. Here, all parents should be on the case plan, regardless if they're in prison or not. They have a right to be on this case plan. And then about counsel and knowing what he was doing. In our brief, on D4 in the appendix, we have a letter that was in the record that went to counsel saying, I haven't heard from you, I don't know what's going on. Can you please tell me what's going on? Let me know what's happening. And then the response he gets is finally on November 4th from counsel at D6 indicating, I withdrew as counsel. All that time period, he didn't know what was going on. His voice was silenced, one way or the other. He wanted to have a CASA, guardian ad litem, appointed. The rule reflects to the point of it is that if there's a disagreement in the best interest between the children and the parents, a CASA should be provided in a dependency manner. Here, mother was claiming the children didn't want to talk to him. He is still a parent, even if he's in prison. There is a disagreement then between the children and the parent, technically. There should have been a CASA there. There should have been somebody looking out for their rights since his voice wasn't heard. And he did tell the court in a hearing, and it's in the transcript, that there is an ongoing new allegation of abuse.
But most of the cases that talk about a conflict between the mother and the child relate to disposition, where the child has been found delinquent and the parent is looking for one thing and the child is looking for another. This is the way that you phrase this conflict can be virtually anything.
Well, I was just reading the law, the case law itself that said that the conflict between the child and the parents as to the outcome or the interest of the child. Here, I'm just saying, illustrating the point that there was a conflict technically, that according to the record, that there may have been a conflict. I'm not even sure that there was. The mom was reporting that the kids didn't want to talk to father. And so there might not have been a conflict as opposed to mother's rights, but I still think as far as father's rights, there was a conflict. Again, Your Honors, I appreciate your time. I do believe that this is simply that there's too many different positions in this case. It has to be one or the other. It cannot be all of the positions. Anthony Wilson respectfully asked this court to reverse the trial court's decision, reopen the case, appoint a counsel or guardian ad litem, add him to the case plan, and allow his voice to be heard. Thank you.
Thank you both for your presentation. Your court will take the matter under issue written opinions to both sides, and you can find our released opinions on our website and the Supreme Court website. Thank you.
Thank you.